Okay, well, I'll call this meeting to order. This is a continuation of a hearing on the Proven Ledge LLC abatement request. And we tabled it last time to give the town time to see if they could find documentation that the taxpayer had accepted the time frame extension and to give you time to see if you could find documentation of that. Nobody's here from the town, and
I did not receive anything from anyone from the town in terms of I think the question that was raised last time was that initial 60-day period between the application date and the date that request would be deemed denied. I think February 20th of 2024. The question was whether there any written agreement or memorialization of an extension of time for that initial period. And that was what the time frame was. I had not received anything or heard anything from the town side on that.
Okay, and I looked through this folder that Carlin prepared for us, and there's nothing in there that documents it either. So I said the town has nothing to document that. So I guess the question would be whether you guys have found any documentation of that?
So no, there was a confirmation email that said there would be extensions happening on February 29, but there was a phone call ahead of that, because my sister called ahead of the 60-day date in February, and she was verbally told that there was an extension, but it was not in writing.
Yeah.
So,
And that's probably why the assistant had it checked off. I don't know, because there was a conversation on the phone.
so that would sound like we don't have any jurisdiction to hear this.
Yeah, and so the statute requires that, again, that either the Board of Assessors takes an action on the abatement request within that 60-day period, or that there be something confirmed in writing that extends that 60-day period for that initial, abatement request. It does not sound like there was anything within, in writing prior to that February 20th, 2024 date.
Right.
And that is the way that I've written up the draft decision, because I think that was the understanding from last time. It doesn't really sound like there's anything that changes that from the understanding from what we already have in the record. So,
I guess I have a question. Why were we invited then to the hearing on April 17th? I mean, we got the letter in March with the denial, and we were invited to the hearing on April 17th that I showed up to, that nothing happened.
And how many other?
So why is that okay?
And how many other 45?
being invited, well, do you want me to respond to the question?
Yeah.
Okay. Being invited to the hearing does not necessarily mean that there's jurisdiction on the part of the board. The staff who set up the meeting and set the agenda may not understand what the statute requires in terms of the board's jurisdiction. So just being invited to a hearing does not necessarily confer jurisdiction on this board, is my point.
Well, I would argue that point, because it wasn't just the staff. We had conversations with them about what that meeting was going to entail.
And what role do you play representing the town and making sure the town is following state procedure?
I'm only, if I'm asked the question, I respond to the question. I was never asked this question. I was never consulted prior, but it's not about me. It's about whether this board has jurisdiction over this hearing or not. And as it stands right now, without something in writing prior to that February 20th date, that initial 60-day period was not extended, which means that your application was treated as denied on February 20th, and you had 60 days from that date to file an appeal.
Correct. And
you filed an appeal
I'm very knowledgeable on the timeline that's involved. This is why, actually, I think I attempted like 3 times and finally got through.
Yeah.
To find out on the 60 days, because we knew the 60 days was coming up.
And she was told it was being extended.
Yeah, so if the town of West Bath did not put it in writing, is that our fault?
Well, again, the statute
Oh,
requires...
no, I haven't answered the question. Is that our fault?
This says unless the applicant...
I know what that says.
Unless the applicant in writing has consented to further delay. So it's on the applicant to consent to further delay.
So I don't think any of this is your fault. I just think it would.
I'm just telling you what the statute says.
I understand.
I'm not assigning blame to anybody. I'm just saying what the statute says. All I'm here is to advise the Board of Assessment Review as to whether they have jurisdiction over this appeal. My opinion is they don't.
So can I ask another question? How many people in West Bath does this happen to? Are we the only ones?
I don't know.
And I don't know, because this board was not part of any of that prior process.
And also, the town of West Bath told us, and it's in there, and they changed the language in the ordinance, that the select board sit as the town assessors. Now, do you oversee them?
I don't oversee anybody. I'm the attorney for the town, or I have been the attorney for the town, and so I serve at their pleasure, and when they ask me questions, I respond to them. I don't oversee them.
So basically, his role is to give us legal advice, legal opinion, and then it's up to us to decide.
Richard, I have a question. So the folder that you were given, that's got whatever records the town clerk or administrator would have come up with?
Well, I assume, I don't know, the town administrator is apparently on leave, administrative leave, so.
Just to clarify, what is the folder consist of what we had already seen last time?
Yes,
Okay, all right, so it's nothing new in that folder.
it even has stuff in here from a prior hearing we had on another case, which has nothing to do with this case.
And in the decision, I tried to lay out what, at least it seemed to me, was the administrative record for this case, so and we can run through that as we talk about the decision in terms of if there's anything that's missing from that. But I think that covers, there was not a whole lot of documentation, but, you know, 'cause it really comes down to the time frame, you know, the timeline, so.
I got one other question. Is there, since, you know, basically, they're paid by the town, or sit here for the town, but governed by the state, is there a uniform procedural format that all towns follow?
What do you mean?
Procedural, I mean, how to conduct a meeting in the process.
Well, I mean, you mean like on the timelines, or?
No, I'm talking about as the meeting is conducted.
You mean how they open the meeting and
Yes.
allow one side to speak and the other
Yeah,
side to speak?
yeah.
There's not a, I don't know if there's anything laid out in statute or anything like that, but, I mean, each board sort of has their own style, I would say, but, I mean, it's just, you know, I think it's typical to have, open a meeting, allow the applicant to speak, allow the assessor to speak, and then, you know, have deliberation. That's kind of what you all have done in the past, you know, so that's, yeah, I don't know. I'm not sure what your question is getting at, but.
Oh, I'm just curious because, I mean, we've been to others in other towns and nothing's run like this.
Well, I'm just wondering, did you have a problem with the way that this board has run this hearing process?
It's not what I'm accustomed to.
In what way?
Well, first,
Well, we didn't have any introductions, we weren't sworn in last meeting, we don't, no introductions at all. So that's unusual.
Well, if there's something that you would, I mean, this case really comes down to the jurisdiction question, so if there's, I think the board should probably allow, if there's something that they did not allow, or they did not get to say last time on the question of jurisdiction that they would like to, you should certainly allow them to have that opportunity, but it's not I'm not accustomed to boards, administrative boards being sworn in. That's not typical. I sat on the board of zoning board of appeals in Portland for 3 years, and I don't think a single witness was ever sworn in at a ZBA hearing. So it's just not something this is not a court of law.
that's zoning board of appeals.
Zoning board of appeals, yeah.
So the last meeting that I was at was a different meeting, is what you're saying? The town selectmen meeting that they did this swearing in, that was different than this, I guess.
I wasn't at that meeting.
It really doesn't matter, I'm just really annoyed with everything about this procedure right now. And like the time it's taken me every time I've driven
Yeah.
here.
We've been at this since September. Okay,
Yeah, I can understand your frustration.
okay, and the town has misled us. The town has given us bad information. The town has done nothing to correct anything. And here we are still hit with a property that is way over assessed. Here we are, okay? And now he's saying that because the town screwed up and didn't put something in writing for us to agree to, it's our fault. And I find that very, very wrong. I mean, you want to be disrespectful to the residents of this town, that's it right there.
Well, I'm sorry, I mean, we
Yeah,
can't
so,
go by
I mean-
what the law says.
Yeah.
We weren't part of any of, I mean, I understand your frustration, and I think there's probably a lot of other people in the same boat with you. The town had an assessor, they let him go, I don't know, a year or more ago, and so they hired this reassessment, and they haven't had the expertise on staff to know what assessing is. So, yes, I think the board can agree it's been a mess.
Well, the town of West has dropped the ball since 2006,
Finish, please.
when they went and put an easement across the entire frontage of that property, and didn't go back and adjust the assessment card, didn't attach that easement to the deed. It was a separate deed filed with Saginaw County Registry of Deeds all by itself. So this was at the time when Karen was losing her father and your mother, and mother was the one that signed it. There was no way that the kids to know this easement even existed until I came across it doing a deed research. So from 2006 to 2024, that property's been way over assessed, and we're looking at tens of thousands of dollars that you have billed Truman's Ledge LLC since that time. All because of the dysfunction of West Bath.
I don't think this board can speak to that. I mean, we were not part of that, we have nothing to do with that. We're not the assessing agents for the town. We had no knowledge of any of that stuff. So, I mean, I appreciate your frustration. But this board has to operate on what its guidelines are and what the law says.
Go ahead and vote so we can get out of here, because we've wasted enough of our time driving back and forth down here. Was this our sixth time or fifth time?
Yeah, just.
So, yeah.
You have any questions or comments you guys want to make?
I'd just like to express sympathy with your situation. It does seem that circumstances were unusual and they were undocumented, and so that to me is a process that was faulty. That being said, it has led to where we are now, which we have to follow the procedure in the law, so we're not able to do anything here as a body. If I understood last meeting's comments that this tax bill will come up again, another 3 months maybe, or something like that. So it's another entry point to address this situation again, and you will have your documentation and your experience to bring forward. So,
Well, we had the experience the first time.
Well,
It's the town of West Bath that dropped the ball.
I just mean in terms of
Redoing it
Yeah,
over.
I mean, if you, your experience will give all the evidence, all the procedural things that need to be done next time, assuming that you will come back at this. So then there will be a written record, and then this body will be able to build.
Yeah.
I think the town will learn, you know what I mean,
Well, hopefully,
gain
it will-
experience too.
hopefully
but,
it'll go different the next time, because the town has just hired an assessor. So hopefully, if you file an abatement request, the new assessor will be able to look at all of the issues you have raised, and it may well be that the new assessor will agree with you and make some adjustments. If not, then, you know, you can proceed through the process, and you'll be back before this board, and then we'll review it.
What's the new assessor's name?
I have no idea. I just learned that half an hour ago. from the tax collector. And I guess they've hired a new clerk as well, so.
They hired a clerk.
And the town will have time to get procedure solidified.
Well, hopefully.
Hopefully, from this experience too. That's for
So
sure.
how would you like to proceed through the decision? Would you like to have a chance to read through it, see if there's any changes that you want to make? This is obviously just a draft that I had prepared in advance of this meeting. I'm happy to also read it out loud into the record if you'd like to. It's only a couple pages long, so whatever your pleasure is.
Yeah, I don't know if any need to read it in the record.
I'd like to read through it.
Yeah, if you want to just take a few minutes to read
Yeah,
through it, see if there are any changes that you need to make. And,
Yeah.
Can I ask a question?
Sure.
Under the jurisdiction, the 60-day time frame is listed as April 20th. I went to that meeting thinking I was going to a hearing, which was April 17th. That isn't, the fact that we were invited to a hearing with the assessor doesn't matter, doesn't imply that we are.
Well, I'm just looking at when the application was received by the town on June 2nd.
Right, but I didn't think we needed to file a new application because we were still being acted on that first.
But you weren't, because that was actually deemed denied on February 20th.
So that's the ignorance that I didn't know that it was deemed denied because I didn't respond in writing. Is that what you're saying?
Well,
The
no.
town didn't let me know and I didn't respond in writing by February 20th.
But by February 20th, there was no action by the assessors and nothing in writing to extend that period of time. And so their jurisdiction over this abatement request ended on February 20th, and then
Okay.
it only comes to us before this board when there's an appeal filed, which happened on June 2nd, and that was more than 60 days after that February 20th date. So that's.
Okay, so we got a letter from the town March 19th. So that's the issue, is that it was beyond February 20th.
And so they were not able to do any extensions or anything after that February 20th deemed denial date. So whatever happened on March 19th
It was
really
a denial letter.
was
It a
not-
denial.
was not actually effective because it already had been denied on February 20th. You know, that's what that.
That's the frustration though. This is the evidence of the town that sent us a letter that said it was denied, and the date on it is the letter date is March 19th, and it was emailed to us on April 10th. So that's the letter that was denied, and that's the issue, is it's after February 20th.
Yep, understood. And I I understand that was some confusion on someone's part, but
More than just confusion. More than just confusion. That's not quite the right word. Misleading. Very misleading for us to get a letter on March 19th that we're denied and then to invite us to a hearing. Anyway, I've said my piece.
did everyone have a chance to read through it?
Yes.
Any changes that are needed? I did leave a blank for the board member who was not here, so I couldn't remember
temporary chair.
Wait, so am I mistaken that there's not a board member missing?
I've got a Chester Garrison as an alternate.
Yeah.
On the agenda.
No, okay, so,
I don't know if that's
no, we don't
I
need
have a
to,
question on it.
so,
Tony did resign
Oh, okay.
at the Thursday selectmen's meeting, not last night, but 2 weeks before.
okay,
He accepted her resignation.
okay.
Oh,
So we don't
well, that's
actually,
news.
so we don't actually have a board member
Okay.
absent, so you can just strike through that when you sign it with the decision. But we do need to have a motion and vote on the written decision, once you're comfortable with it. So
Okay.
and then we can fill in the vote, and then I think you can just cross off the board member blank as absent, because I thought that member was still, you don't need to, I don't think you need to signify if an alternate's absent, because they're an alternate anyway, so.
So can we have a motion?
What are you referring to in the document here? Is the
Oh.
person that's not?
Yeah, on the second page, where it says vote, I just left it blank for,
Okay.
and then I guess I thought that Richard was the acting chair. I guess you are the official chair. So, lucky you. So you can also strike out acting, because I think you are the actual chair of the board. So that's all I was referring to, as I left it blank there. But no, I think it was just a matter of a motion and second to adopt the written decision as drafted.
Okay, we had a listed motion, do we have a second?
Can you repeat the motion again?
Motion to deny based on the jurisdiction.
To that, okay. I would second that.
Okay. Any discussion? Seeing none, those in favor? Okay, so it's,
And then that's, you've decided, done a motion on the decision itself, or on the request itself. I think you just want to do a motion and second on the written decision, adopting that as the board's decision. You understand? Because I'm the one who drafted it, and you want to have a motion that you're adopting that as the board's written decision in this case. So just a motion and second on that. I think.
okay.
Motion that we're adopting the draft as a decision.
I'll second that.
Okay. And any discussion? Those in favor?
Before we close the meeting, do we have to do signings here, or?
Well, it's set up to, the written decision authorizes the acting chair, which is actually just the chair, to sign the notice of decision on behalf of the board. So that's the way it's set up. That's what we've done in the past. That's all right. I mean, I can change it to have everybody sign if you prefer to do that. That works.
I'm happy to discuss that.
I'm happy to do what we've done in the past.
Okay. All right.
Okay.
Before adjournment, I would just like to recognize that there's somebody in the audience here. If you'd like to make a comment, I would like to hear.
I greatly respect the appellants, Mark is your consultant, is your advisor, and the three of you for what you have accomplished with the limitations placed upon all of you. It's greatly respected as a member of the community.
Great. So throw that back at you, say, you're a resident of West Bath as well?
Correct.
Yeah. So
She's
just
the
thank
former
you.
chair of this board.
I'm sorry?
She's the former chair of this board
Perfect.
for many
So I want to
years.
thank you for the public being here.
I guess we do have to approve the minutes of our last meeting.
Do you have notes?
Do you have them?
No, I
They were
don't.
emailed out, I know.
Oh,
We're emailed out to us.
well, really?
Yeah, Julie, oh yeah, Julie.
Of course, I was not here for either of those meetings, so.
You were
No,
here for the last
no.
one.
The
last one,
one.
the
Oh,
one you were
yeah,
at.
yeah, okay, the last one, sure.
She knows, you want me to have her everything?
Yeah, I might do that, and then you can take care of that, because it's not clear when you're gonna meet again.
You just, you want a copy?
I think there's someone here there.
Thank you for coming.
I got a copy.
Do you want to turn off the video?
Uh,
Or keep
well,
the
the-
tape?
Yeah, we're still in the meeting, so we can just,
So I copy it here, I think this is what, right?
yeah, it's fine to review it on the computer as well, so then you don't have to print them out.
No question, I know that,
Mm-hmm.
you know, everyone's gone. In the vote, it says vote was in favor or opposed. If there was opposition, how is that handled?
What do you mean?
If there was, you know, how many in favor of the board, how many opposed with this decision?
Well, it could have been like 2-1.
Yeah,
One, yeah.
I mean, yeah, in this case, you know, that's usually more typical when there's a vote on the merits as opposed to a jurisdictional vote, because it's, you know, it's kind of just,
Technically, there's nothing we could do.
it's like more of a black and white thing, whereas the merits is more of a gray area kind of thing, so you may have like a 2-1 vote or something like that, but yeah, that would be,
There's no argument with the jurisdiction. It's a timeline thing, it's a state statute.
yeah, I think it's pretty clear based on the evidence that you've seen, and that there just wasn't anything in writing before that date, unfortunately. I think that's just kind of, there's nothing that you can do as a board to sort of, it's not like you can say, well, you know, I think they're entitled to have those time frames relaxed or something like that, because that's just not something that you have jurisdiction, the authority to do. If the time frames didn't get met, then you just can't even hear the merits of it because you don't have any jurisdiction to move forward on it. So that's what.
Well, couldn't we ignore your legal advice and move forward anyway?
You could have. I mean, if you wanted to. I mean, you'd also be ignoring the statutory provisions that they give you
And then
give you
if
jurisdiction. So.
and if we denied them, they would have grounds for appealing because we didn't have jurisdiction to deny it, right?
Yeah, I mean, I suppose that they would, you know, that would be something that they would appeal on a jurisdictional ground, but, you know,
I mean, there's no way that we could have accommodated them recognizing
no.
the fiasco this town has been through.
And then, as you pointed out, I mean, every April 1st is a new year, so they will have a chance. This decision does not affect their ability to move forward an abatement in a future year.
Right.
You know, so they have, you know, after the April 1st of 2024 that just happened, you know, tax bills will be going out soon and stuff. So they'll have another opportunity, another bite at the apple, you know.
Financial compensation, will that be given? And I guess the unfairness of the town not having something in place and being disorganized with the process and
Well,
it being on the town's fault.
I mean, part of this is, you know, I mean, from my perspective, you know, it's not on the town to advise people of how to get an abatement from their own taxes. If they want to pursue an abatement, they need to do the research of the statutes, of what the provisions provide, what they require, what the timelines are. If they don't understand them, they can consult an attorney who will help them understand what they are. And so, you know, if they're, you know, coming up against that 60-day period and they haven't heard anything yet, you know, it would be on them to reach out to the town and say, you know, we haven't heard yet, but we consent to a further delay. Or, you know, we know the statute requires something in writing, so we're providing something in writing. You know, so I understand that their perspective is that this was all the town's fault, but I think you have to see both sides of it. That the taxpayer, you know, even if you're not represented by an attorney, you're expected to know what the law is. And you know, the laws are on, you know, the application forms and stuff. Anyone can go and look them up. They're available online. You know, so I understand that there obviously was some, you know, maybe some confusion on the part of the town or whatever, but it's also on the taxpayer to know what they're supposed to do with regard to an abatement. So.
Well, the last hearing we had, they had a lawyer and they did have everything lined up and we had jurisdiction and we.
And you had jurisdiction on it, yeah. So.
I had a question about, these meetings are frequently videotaped, right?
This one's being videotaped right now, yeah.
This one
Yeah.
and the Would that have been a written record?
No, what do you mean, a written record of the
Well,
extension?
Yes.
Time? No, I mean, something in writing would be either a letter or an email or something like that. That's the problem is the verbal, thing, then people will disagree later on what was said, oh, they said that I had another 60 days, or they did not. That's why everything's done in writing, so there's something, written down, to see what was intended. Something that's recorded on a videotape is not in the eyes of the statute, something that's writing, so they'll need to have, I mean, this is done all the time, this is not uncommon. You have a taxpayer who's filed an abatement request, you're coming up on 60 days, the assessor needs more time, they reach out, either they reach out to the taxpayer, or the taxpayer reaches out and says, where are we on this? And they say, let's agree to another 60 days, and so there'll be an email saying, the new deadline is such and such a date, we're agreeing to this extension. It's very simple to do. You can just do it by email, between the assessor, and it's good that, now that you've got an assessor, it will be even easier because then you're not dealing with a whole board of assessors, you're dealing with just one person, so that the taxpayer can reach out to that one person, say, I'd like to agree to an extension, and then memorialize that in an email or something like that. So it is quite straightforward when the process it's not something that needs to be, get approval or something like that. It's basically just in the discretion of the assessor to say, yeah, we're not quite there yet, we need some more time, and it's usually readily agreed to. So that's how I would see it, moving forward. And again, now that if there's a single assessor, then that would make things that much easier.
Why don't we vote on the minutes and then we can adjourn, and then if you have additional questions for the attorney, we don't really need to record all that.
Sure. Okay.
Okay, so are we ready to vote on the minutes?
Yes.
Okay, do a motion to accept the minutes?
Move to accept the minutes as written.
I second that.
Okay, those in favor? And any other business for this board?
I don't think so.
Okay, a motion to adjourn?